This is Mark Johnson with News from the Front. I want to talk today a little bit about something that most of us don't like even to think about because it's an incoherent, incomprehensible subject, and that's land use policy in the United States. The policy set for land use is confusing because it's not clear even in the Constitution. If we look at the Constitution, Article 4, Section 2, Section 3, this is about all it says. The Congress shall have power to dispose of and make all needful rules and regulations respecting the territory or other property belonging to the United States, and nothing in this Constitution shall be so construed as to prejudice any claims of the United States or of any particular state. The problem with the land use policy is the Constitution doesn't spell it out, and there has been a sort of de facto agreement among the people of the country, the states, and the various interest groups that we wouldn't have any set policy regarding what land is owned by the state, managed by the state, and so on. The problem is the situation in the country has changed over the past 240 years. Originally, we were mostly just a eastern seaboard country, nothing really much east of the Alleghenies or west of the Alleghenies. And as we moved west, of course, there were major changes that happened. You had the Louisiana Purchase. You had Indian rights, Indian reservations that came into play, and you had the creation of new states as things went along. But as you go west, the states are sparsely populated. The geography of the states is quite different, and anything that would come into play as far as what should be the rules or the statutes regarding the land was variable. So in the West, like I said before, the interest groups wanted lands to be continue to be public, and that was ranch owners. It could be businesses. It could be people that were in favor of government control and so on. Most people felt that they could use political power and influence to gain sort of a de facto use and control of the lands. And that worked okay for a while. I mean, you had people, even now, you have people that use public lands for grazing rights and so on. And then you have certain dispensations for national parks or for forests, and you have mineral rights and so on. But in each state, there are unique circumstances, and particularly I want to focus today on Oregon. Oregon has unique kind of situation, being one of the westernmost states in the country. We were very sparsely populated back in the late part of the 19th century, and there was a need to, as we went west, the national government wanted to subsidize building railroads, basically arteries throughout the country, so that there would be transportation. And along these arteries, certain land rights were granted to the railroads. This seemed like a equitable solution because it was, there was a cost factor, and they wanted the railroads to be take the lead, be private enterprise in a way, even though there was a private-public sort of partnership going on, certainly. And so in the West, basically the population center was the Columbia River and Portland, and down south of us, south of that point, you had San Francisco, major ports, both of them. So they wanted to build a railroad that would connect this sparsely populated area. It was rugged terrain. It was in some ways inhospitable terrain, and they wanted to build this railroad between Portland and San Francisco. So they decided they would work out a deal. There was the creation of a railroad called the Oregon and California Railroad Company. Later that was changed to the Southern Pacific Railroad, but at that time this was set up, And then they came up with a land grant arrangement that would basically build or create a structure of land management around the railroad that was quite huge on both sides of this area. And this is western Oregon, of course. We're speaking about land west of the Cascade Range. This area was basically a large portion of this area, 20 miles on both sides, in some cases even 30 miles on both sides of the railroad. There were 160-acre parcels in a checkerboard fashion so that no two were adjacent to each other, and these were allocated all the way down through this region. And this area was going to be used by the railroads to sell as property to settlers. So there was an agreement between the Oregon and California Railroad and the national government that they would take this land and sell it as part of the compensation, or as the compensation for the building of the railroad. And certainly there would be the theory was there'd be increased population, and property values it would be worthwhile for people to move in, and that would accomplish the goals of the country. They wanted, settlement of these kinds of places throughout the country. But like so many things, you have the law of unanticipatable consequences. And nobody could see at that time what was going to happen with the settlement. Would people actually move here? Would people buy this land? Would people settle? And what was the nature of the land? I don't think they really understood, whether this land would be useful to a settler. And so the idea was that the railroad would sell this land as part of their compensation. They would certainly have compensation through the basic interest of having a railroad and having the business economic benefit of being the primary artery between these two major population centers. But at the same time, it was unclear, there was assumptions that were made that were faulty, and it didn't really work out the way they wanted. But the question about who should own this land, even should the national government own the land in that situation, was not really questioned at that time. Most of the land, when a state was set up, there was no provision in the Constitution or anywhere else that said that the state will now have possession of that land. Whether that should be a provision in the Constitution, an amendment in the Constitution, I'm not qualified to say. I don't know if anybody is. I think at this point in our history, the case could be made that land use should be devolved back to the states. But we are so far down the rabbit hole on the way that the land has been allocated and set up, and the administrative agencies that have been set up. It would be a massive undertaking to back out all of this and to reach a political agreement that would say now the states are going to have control of all the land within their borders. Personally, I think this would be a good way to go, but there would be a lot of considerations, and you would have to look at the political aspect of it. Would a state, for example, want to pay for administering national forests, or for areas that would not be used for economic benefits? Maybe they're recreational areas, or they're a national park, let's say like Yellowstone or Yosemite. And so you would have a whole financial economic ecosystem that would have to be set up to preserve those kinds of things that I think all of us value. There are certain natural beauty and natural wonders that we do want to preserve in a certain way, but how we would get to that in a political sense is not clear to me now. So I'm going to take a few minutes here, and we'll talk about the Oregon and California Railroad lands, and I'll bring up a picture here that we'll talk about sort of as a reference point. Okay, so in this diagram you have the western part of Oregon with Highway 5 running down the middle. This green little blotch here is a star. That's Roseburg. And as you will see, it's hard to see on this picture, maybe on your screen, but you'll see these blotchy squares that have been, pasting on the diagram all the way down, kind of on both sides of Highway 5. And these are a mishmash of property allocations. Some of it is BLM, some of it is National Forest, and then there's different kinds of BLM forest and so on. Let's go down. Oh. Okay. Go down to this picture here is the key for this diagram, which you can get online. Western Oregon Land Tenure and Special Designation. Okay, so as you'll see here, you've got BLM Forest, Bureau of Land Management. This is not part of the Oregon-California Railroad Company lands, but BLM, the Bureau of Land Management, does manage and administer the ONC lands, the Oregon-California lands. And then you've got some other designations here, which you'll see if you look at this diagram, but it's too detailed to look at online. But you'll see in the diagram light, sort of a darker brown, that's National Forest and ONC lands, and then the light brown, which is BLM and ONC and CB, and I don't know what the CB designation actually means. So this is a little bit of a zoomed in picture, and you can see again it looks like there's some ambiguity here, but you've got these blocks with some color mixed in there, and I'm not sure if those are just not depicted properly or not, but it looks like this is the light brown color, which is ONC lands. You've got this sort of brownish, darker brown up here, which is would appear to me to be ONC lands, and again you can see this checkerboard. And so you can see quite a ways away from Highway 5, or this basically where the rail line would go. You've got large swaths of land here that have been allocated. And I'll go to the next picture. So this is just sort of for Douglas County. You can see the perimeter of the county, and just generally you get a feel for the ONC lands here. Coos County, of course, is down here, and so on. Josephine County below, Jackson County. So there's a fair amount of land here, a considerable amount of land that is controlled under this ONC Lands Act, which we'll talk about. Okay. So in 1866 to 1870, like I mentioned, the railroads, you had the Transcontinental Railroad, of course, and then you had railroads that were being built in other sections of the country. You had the Oregon to Railroad between Portland and San Francisco, and that land was allocated to the ONC Railroad Company. About 4 million acres were set aside for this as an incentive, and you see those sections. The agreement was that the railroads would manage this land and sell it to settlers, and so they would sell in 160-acre blocks, and these would in theory be people that were settling, newcomers into the state, and they would use the land as farmland or whatever that people would use in those days, and that was the idea. Typically, people did not buy land to become timber, to manage timber. That wouldn't be the way it would be done. They would be basically farm or homesteads. The problem was the land wasn't, here in Oregon, this is where each state is unique. This is essentially a volcanic, we're dominated by volcanic artifacts, especially from the Cascade Range west. East of the Cascades, it's more arid, and it's more a little bit like high desert and so on. But west of the Cascades, the Cascade Mountains, essentially you have a range of volcanoes. You have a lot of rugged terrain, sort of mountainous, steep terrain with a lot of trees, of course, forests, river valleys, and all of this coming west as you go. There's mountains that have been built up over the millennia as the continents have come together through the Cascadia Fault and so on. So it's a unique sort of topography that it makes it difficult. There isn't a tremendous amount of farmland. There are farms and significant farmland here, but it's not totally open and amenable to all of this land being used for settlers who want to set up a farm. And you, of course, wouldn't necessarily have roads, and you wouldn't have infrastructure and so on. So as it turned out, the railroad was not really able to sell a lot of the land. And of course, they had to pay taxes on the land, which whatever tax rate was set up by the state of Oregon. And as far as Oregon was concerned, that was fine. They would be getting some revenue from taxes, and the railroad would own the land up until such time as they were able to sell it. The problem was the railroad didn't want to abide by those rules, and so they stretched the rules and sold the land in violation of those terms to non-settlers, people that wanted to leverage the land for its timber, because the timber was clearly the most valuable aspect of the land, and there were certainly people that wanted to come in and take advantage of the economic benefits that would come from logging. Approximately 820,000 acres out of the 4 million were used or sold off by the railroad to use for timber, or sort of a large segment of it was in violation of the terms. So that was by 1887. So here we're talking about land use policy that stretches for well over 120 years, and we still haven't resolved it, as you'll see. So at some point, in 1903, the O&C Railroad withdrew. They were getting pressure for this violation of terms. They realized they were probably in breach of their agreement, and so these lands were withdrawn for sale. They just weren't selling the land, and it wasn't really doing them much good. Around 5 years later, you have lawsuits, and you have the state seeking sort of Congress to intervene and deal with this situation, and by then it was Southern Pacific Railroad. So the Attorney General steps in 1908 and says, we're going to seek forfeiture. So we're going to say that the O&C Railroad is in breach of the agreement. We're going to seek punishment, basically by saying you forfeit the rights you had to this land. And so in 1911, 3 years later, everything moves slowly, court system. In 1911, the district court rules that the lands would be subject to forfeit. 1913, as a result of this decree, the railroads stopped paying taxes. And by 1915, there was a ruling by the Supreme Court that something would be done differently. So essentially in 1915, the act called the Chamberlain-Ferris Act, one of the more significant milestones in this journey we're going on the O&C lands, that was passed by Congress as a result of the Supreme Court's ruling that something had to be done. I think the complaint was that as things stood, the state was not getting any revenue, and there wasn't really much. The railroads felt that they were being it was an unfair agreement in some ways with them, even though they had been in breach of the agreement in some respects. But nobody was really happy, I don't think, at that point. So in 1915, the Chamberlain-Ferris Act is passed, and all the lands at that point were then, they called it revesting. So they took the land and they said they'll be vested back for the United States to administer. The railroads were going to be compensated for all of these lands at a rate of $2.50 an acre, and Oregon would have to accept that. The problem was, of course, that once the land was revested, there wouldn't be any revenue at all to the state. So Oregon at that point, and really for many years after that, for 50 years after that, the state of Oregon was bitter about how this arrangement actually transpired and whether it was done in a really democratic or in a fair-minded way. So in 1916 to 1926, during this period, the Chamberlain-Ferris Act really didn't produce any revenue, and there was a problem with the tax revenue and whether what would be done, and so at that point, by 1925, the Association of Oregon and California Counties was formed, and that association still exists today to try and advance the interests of the counties of Oregon that are influenced or affected so severely. I mean, if you think about it, again, in most of Oregon, not counting the major population center of Portland, and maybe to some degree Eugene being, mainly a college town, but even outside of Eugene, most of Oregon, south of Portland, there's a lot of forest. There's a lot of, there's not a lot of population. It's sparsely populated. There's a lot of rural area. And farmland, while farms are there, and some of them are prospering to some degree, there isn't really much way of having economic growth or financial growth, fiscal growth in the southern part of the state in particular. And so the only way that is open for Oregonians at this point is we're not a manufacturing sector, we're not primarily a farming sector in a true sense, in a large scale sense, because of the mountainous terrain and the way that the land is set up. It's not really amenable to a lot of farming, and even if it were, it's not a large area where you have enough area where you're going to have prosperous farming, you're going to have merchant sort of life and economic life, and then decent population centers. Population centers don't really have any really good source of revenue, and so really here some method of leveraging the forest management is a way to do this. Some kind of sustainable, reasonable timber industry is needed to help provision the economic life of this part of the state. So in 1926, it's a long time ago it seems like now, but the Stanfield Act was passed by Congress, and that was going to say that payments to, well, I'll go back a little bit. So under the Chamberlain-Ferris Act, the land would be sold to settlers, but there weren't a lot of settlers even throughout those years. From the time that the original grant land was revested to the United States government, and then you had this situation where the land would be sold to settlers at a fixed price or whatever, and you would have property taxes could be assessed at that point. So, but it just wasn't happening. People weren't moving here in droves. They weren't buying the land and paying taxes. It just wasn't going to work well. And so under the Stanfield Act of 1926, payments to the ONC counties from the federal treasury would be made, and these were called in lieu taxes. In other words, they were going to help financially, fiscally strapped areas in this part of Oregon, and especially in southern Oregon, with these in lieu taxes. They would pay them what they would have gotten if there had been private ownership and if they'd been paying taxes. And then this would be reimbursed at some point whenever the sale of the land took place. Then there would be a reimbursement to the federal treasury. The problem is that wasn't really changing anything, and so you had a continual buildup of debt in the federal treasury against this ONC counties fund. And from 1926 to 1936, of course, most of us know, you had in the middle of that, you had the financial collapse, you had the depression, the onset of the depression, and for some time afterward throughout the 30s and even the 40s to some degree. So you had a Certainly no revenue would be materializing from land settlement, and there wasn't any real economic growth during that time either, so you weren't going to have a timber industry of any substantive amount either. And so you had an ever-increasing reimbursable fund, and eventually the federal government just stopped making payments. There was no apparent end in sight, and so they just said, we're not going to make these payments. And so this led to a crisis because, of course, you had a fiscal crisis here in Oregon. And then in 1937, they formed in 1937, there was also criticism of the way the land was being managed for the timber industry. The General Land Office, I guess this would have been before the Bureau of Land Management, but in any case, the way that they managed the timber, the forest, they weren't dealing with it in a sustainable way where they were replanting and so on. So there just was a real problem with the way that the laws were set up at that point under the Stanfield Act. And so in 1937, you had the O&C Act of 1937. And that is still, in large part, the governing law that affects the O&C lands that still exist under statute law at the national level, applying to all of these lands that have been defined and existed ever since the building of the O&C Railroad. Under the O&C Act of 1937, there were provisions made for sustainable yield. Generally, this took the form of looking at the total land or the total forest that was under consideration, considering a 100-year growth cycle, how much forest could be harvested over 100 years. So you would take 1/100th of the land, you would harvest that timber in that area, and you would each year just harvest that much, so that it essentially, by the end of 100 years, you'd be back at the beginning, and you would have a sustainable yield, they called it. There were also issues with the way that the land was managed even after you did timber collection. There were issues with stream flows and managing, the stream flows and the ecology of the area. So there were provisions there to do that in an appropriate way as well. And so under this arrangement, the counties would get 50% of the revenues coming from this sustainable yield timber industry. And at that point, early on, the Department of the Interior appointed Walter Horning as the chief O&C forester. And actually, Walter Horning was a very effective administrator of that plan. He was very systematic, and the plan was a success under his administration. And so from 1937 to 1954, you had something on the order of 600 million board feet on average were realized every year, and this was sustainable. By 1952, you had all of the payments that were in arrears to the U.S. Treasury for these in lieu taxes. Those were all satisfied, and everything was fine throughout the 50s and the 60s, and you had a really booming sort of, very financially and economically prosperous state during those years. Even in 1976, the Federal Land Policy and Management Act, FLPMA, sort of defined a global policy or general policy for federal land management, saying that it would be multiple use, you would have recreation, you would have different things for different purposes, depending on the circumstances. And so that was fine for, preserving, national forests and national parks and things like this, and how those would be used. But the O&C lands were specifically exempted from that, recognizing that the purpose of the FLPMA Act was not really applicable to the ONC lands, given the historical and the statutes that applied to that. So that was recognized, and that was the timber-centric nature of Oregon, and especially the southern three-quarters of Oregon were recognized. And then, even along through the 1980s, everything was fine until you get to the 1990s, and this is where things went bad. You had the Headwaters case in California, related to preservation of forests, and then you had the Northern Spotted Owl. You had the Endangered Species Act, the ESA, and you had, by the time the Clinton administration took over in the early 90s, you had a government and administration who was an activist towards these kinds of things, the preservation or the ecology movement, so to speak, more associated with the people on the left part of the political spectrum. And at a conference in 1993 in Portland, Bill Clinton was there and spoke to this. And what happened is that he set up a Northwest Forest Plan, NWFP, and that plan was set up in a way where the national government, the executive branch of the government, the administration of the government, would have the ability to directly guide and control forest management, so under the NWFP. And at that time, a drastic reduction in the timber yield came to be. And considering the ONC statute minimums, those were reduced by some 80%. It removed most of the ONC lands from the sustainable yield provisions in the Act of 1937. And there were provisions for a management strategy, but those were never implemented. And so you had the beginning of a series of basically, I believe, political push and pull from that point up to the present day. You had the AOCC and the AFRC. Those are two organizations for who representing the interests, advancing the interests of the people of Southern Oregon, or the people who feel that this is a financial hardship on the state. And so this continued on and has continued on since then. In 2003, there was a settlement under the Bush administration where you would have, they agreed to revise the resource management plans within 5 years. This was from 2003, so 5 years would be before 2008. Well, that was fine, except that it never really was implemented. They put a plan out at the last minute, and then the Obama administration took over at that point, and those plans were immediately withdrawn and nullified, and so nothing could really be done. In the meantime, from that point, from 1994 through 2008, there was something called a safety net program. The national government recognizing that this was a fiscal hardship on the state and on the counties of the state in particular that were affected. And there were a couple of different ways this safety net program was put in place. There was something dealing with the spotted owl, the Northwest Spotted Owl. So there was a safety net for the areas that were affected by this. And then you had something called the Secure Rural Schools and Community Self-Determination Act, and that was SRS, it was called. And there were safety net provisions made so that income revenues, there would be money available to these counties to sustain themselves. But once again, it is creating a situation of dependency where you're basically your financial and fiscal, whether it's even tenable at all, is going to be dependent on the national government. And if they choose to change those agreements or withdraw those agreements or anything else, you're basically out of luck. So the SRS program from 2008 through 2015 was renewed from year to year. There were amendments and decreases and various things that were done with it, but eventually it was basically halted by 2015. And so here, we have a situation where the financial feasibility of the counties was dependent on some form of a sustainable timber industry, and that had been taken off the table. There was no provision for it at this point, any reasonable provision. Whatever was being harvested from in the timber standpoint was less than a half, closer to a third of what had been available under the 1937 Act, and it just wasn't enough. And there were always seeming to be issues with whether it was the spotted owl or something else. There would be things that would decrease the amount of yield that they would have. In 2011, just as a note, that 2008 plan that had been submitted by the Bush administration was vacated completely, and so we were back under the 1994 Northwest Forestry Plan, which was implemented under the Clinton administration, which was very, very small amount of yield that they would be able to collect. There was an effort to deal with this, sort of a unified front in 2012 to 2014. The governor and the Oregon congressional delegation made proposals that would have dealt with this in some way. They passed the House of Representatives, but they didn't advance to the Senate, and so once again, nothing was being done. In 2015. I think it would be Representative Wyden proposed a repeal of the ONC Act, and that failed. But at the same time, the Supreme Court did rule that the Endangered Species Act cannot trump statutory mandates of the ONC Act. So there was legal standing for saying that the ONC Act was still applicable. That was under a ruling that happened in 2007, National Association of Homeowners versus the Defenders of Wildlife. In August 5th of 2016, this year, the AOCC and the AFRC filed suit challenging the BLM's 2016 plan, and this is pretty much where we are. So each year the BLM would put up a plan for timber collection, and of course we're still living under these 1994 arrangements. There's no safety net, and there's just not enough here. The counties are going, are insolvent in some ways. They're having to reduce down to virtually nothing, where there's not enough money for even basic, mission critical services like law enforcement, the sheriff department, these kinds of things. And so they were forced to, the only option left was to file suit challenging the BLM, which is responsible for the ONC lands management. This will go on for some time. There's no clear idea of when it'll, if and when this plan will change. It's going to essentially resolve a question. One of the questions it will resolve is the relationship or the interaction between the ONC Act of 1937 and the Endangered Species Act. I think there's a little bit more to it than that. I mean, if you look at the Northwest, forestry policy that was set up back in the 90s, I think that the overall strategy and the way that the land is being used, it needs to be looked at, and I'm sure that's part of the process here. But in the meantime, we're struggling with this situation where we really can't resolve this in any timely way, and so we're seeing counties continually, going down and down from a fiscal financial standpoint. What's the resolution? Should we try and seek some kind of constitutional amendment that would, transfer all of the management of these BLM lands back to the state? While it might be something that we would like to do for Oregon, it's unlikely, in my opinion, that we're going to see that anytime soon. Maybe someday it will happen. Maybe it'll be an arrangement under the Constitution where a state can have the option of doing that, but that's going to be down the road quite a ways, and I'm not sure if it will ever happen, given how much the current policies are entrenched and institutionalized in our governance and the way we do things. And so that pretty much concludes my discussion here, and I'll wrap it up there.